Welcome everyone. So good to have everyone with us here on Zoom, and also those who are watching us live on Facebook. Welcome as well. This is the fifth session of Halakhah for the Ages, reading Responsa from a Bygone era with Dr. Rachel Furst. Just a reminder on how we run the classes. If you get an invitation to become a panelist and you accept it, you will be able to show us your smiling face if you wish, and you would also be able to unmute yourself to ask questions or make comments. You can also engage in the chat here on Zoom or as a comment if you're watching us live on Facebook. Please do stay muted when you're not actively speaking. I will also help mute if you forget. And just remember to simply unmute when you'd like to speak again. And with that, I'll turn this to Rachel.
Great. Thank you very much, as always, for the introduction. I'm just going to quickly share my screen with you so that we can, oops, sorry, one second. Okay. Okay, so as Evie just said, we're already up to our fifth unit, or our fifth class. And this week, we are going to be focusing on actually a series of responsa, two responsa in particular, as you may already have seen on the handout, that deal with, as I said last week, a slightly more mundane topic, a seemingly more mundane topic than the subject of the very first responsa that we saw, which were a little juicier. They dealt with marital conflicts, adultery issues, and defamation cases. Last week, we already began to, again, deal with, as I said, the slightly more mundane by focusing in on also a series of responsa that dealt with neighborly relations, or as we saw last week, the negotiations of light and privacy rights between neighbors. And this week, as per the title that you see in front of you, we're going to be dealing with the topic of securing debts, or guaranteeing loans is another way of putting it, which again might not sound quite as juicy or as exciting as some of the previous ones, but which I think from a methodological perspective will be significant, because in continuation of the theme that we saw last week, what we're going to be focusing in on today in these responsa is the way in which the medieval Ashkenazi scholars, respondents that we've been looking at, dealt with questions of Halakhah, that is Jewish law, in conjunction with, or in conversation with, local law. And to get us started, I actually want to take a step back to something that we ended with last week. Once again, we were looking at responsa, two primary responsa by Rabbi Meir ben Baruch of Rothenburg, who, as we said, was probably the foremost halachic authority in the medieval German Empire in the second half of the 13th century. And in the responsa that he wrote on these neighborly disputes that we took a look at last week, specifically the negotiation again of windows of one neighbor facing that of the other neighbor, in the two cases that we looked at, both involved a dispute between two Jewish neighbors, but under circumstances in which one of the Jews had recently purchased his property from a former Christian owner. And what we saw last week was that the prior or original ownership of the neighboring property by a Christian had a very significant impact on the way Rabbi Meir dealt with the subsequent conflict between two Jews, namely, in light of the fact that the property had originally been owned by a Christian, Rabbi Meir allowed the new Jewish owners to claim rights that would have been valid under local law, in a local legal context, Rabbi Meir was even willing to admit documents, as we said last week, either Latin or perhaps German vernacular documents that had been bequeathed by the former Christian owners to the new Jewish owners. He was willing to allow those documents into a Jewish court of law and to actually hold weight and to determine this dispute, the outcome of this dispute between two now Jewish neighbors whose case was being adjudicated in a Jewish rabbinic court, ostensibly according to the rule of Halakhah. And the reason that I'm repeating all of this or summarizing all of this again is because to get us started today, what I'd like to think about together for just a moment is why Rabbi Meir or any halachic scholar might have been willing to make this concession to local legal norms. Why would Rabbi Meir have admitted these, again, local legal documents in Latin or in German? Why would Rabbi Meir have embraced the local legal methods and norms, as I said, as a halachic respondent ruling in a Jewish court in a halachic context, right? As I pointed out last week, he clearly was very aware of what those norms and what those legal instruments were. But why do you think he might have been so willing, even embracing, of those non-halachic norms and instruments in an ostensibly halachic context? What do you think might have been his motivation? And I'd be happy to hear any thoughts you might have. Anybody who has any is welcome to just unmute themselves and chime in.
I'm going to say shalom bayit in the
Okay,
sense.
what do you mean by that? Can you explain?
In something that isn't of significant halachic importance, perhaps really critical. This is a way to keep peace with the neighbors, good relations.
Okay, so it's a way to keep peace with the neighbor. So certainly we can understand, as long as the neighbors were Christian, right? We can certainly understand, and we can understand, again, as I mentioned last week, it was very common for Jews in the urban environments in which they lived during this period to have next door neighbors who were Christian. So certainly as long as the neighbors were Christian, that makes complete sense. But I want to remind you that we saw Rabbi Meir adjudicating these cases between two Jews, right? Because the dispute came to the Jewish Beit Din, to the Jewish court, once the property that was formerly Christian owned had already been sold and transferred to a Jew, right? As a matter of fact, I'll add to that, that if the neighbor were still Christian, in all likelihood, this kind of dispute would have gone to a local Christian court. It probably would not have come to a Jewish Beit Din altogether. That just had to do with the type of jurisdiction and the context in which the Jewish courts had jurisdiction. So we're talking about, at the end of the day, disputes between two Jews, right? So I don't mean to dismiss your answer at all. I think it might still actually be relevant, but I want to think one step to kind of deepen that idea. Why, in the context of a dispute between two Jews that was being adjudicated in a rabbinic court of law, would Rabbi Meir have been so embracing or so willing to admit local legal norms, local legal instruments? Any further thoughts? Anybody have any additional ideas about that? I do want to remind you that Rabbi Meir based his ruling on halachic sources, including a Talmudic statement which says that haba machmat goy, that a Jew who comes, I'll say by force of or by dint of a non-Jew, harehu kegoy, he is like the non-Jew, which later scholars interpreted to mean that he or she, for that matter, carries all of the sort of legal rights and obligations that the non-Jew would have had. So that was the legal justification for it. But I'm looking now for a little bit, maybe the motivation. Yes,
So
I heard somebody start talking.
there are a couple of possibilities.
Yeah.
That is, so on a formal level, there's Dina de Malchuta Dina,
Okay, great.
but there's also a general
I'm sorry, can I just interrupt you and ask you
so
to
that the
explain
law
that?
of the land is to be accepted in various types of circumstances, particularly in terms of property law
Mhm.
and so, but there's also the underlying philosophical issue in terms of property law and commercial transactions. That's a question of the question of what's the expected outcome, what is the expected contract involved with the transfer, and if the parties are relying upon the established non-Jewish norms, then that would be normally be incorporated into the meaning of the transaction.
Okay, great. So you said, I think, two really significant things that I want to highlight. Let's start from the second one, right? This idea of marital, or this idea of the expectation, right? And so you are assuming, and I agree with you entirely, I think it was very clear that the litigants themselves assumed and expected that the Jewish court would honor these legal instruments, these legal documents that they were bringing in, despite the fact that they did not originate in a Jewish court or in a Halakhic system, right? They brought them to what they knew to be a rabbinic Beit Din, and assumed that they would be upheld. And so that's part of it for sure. And you also mentioned that very important concept of Dina de Malchuta Dina, of this idea that Halakhah recognizes in certain contexts, and certainly the monetary law is a primary context in which Halakhah fundamentally recognizes the law of the land. Dina de Malchuta, Dina Malchuta, meaning the law of the kingdom is the law, but it works, leaving aside the specific political setup. And we'll see that again today. I want to add to all of these things that you've said, just a suggestion that although rabbinic scholars in general throughout history, and in particular in medieval Ashkenaz, and even more specifically, Rabbi Meir ben Baruch of Rothenburg who is the respondent that we were dealing with, felt very, very strongly that the Jewish court's jurisdiction must be maintained. They issued, the scholars of Ashkenaz periodically issued bans and takanot, warning people that they must submit disputes between Jews to Jewish courts, that they must keep these issues within the community, that anyone who took his fellow Jew to a non-Jewish court of law or to a non-Jewish authority was considered a moser, which carried very significant penalties. Despite all of that, or maybe in conjunction with all of that, the rabbis were certainly very cognizant of the fact that there were all kinds of reasons, all kinds of motivations for Jews in a variety of circumstances to actually turn to local courts, to seek justice outside of the halachic system, outside of the Jewish community. And we can talk over the course of today and some of the next classes about some of the reasons why litigants themselves might have preferred to submit their lawsuits to other authorities. But since the rabbis were very cognizant of that reality, they also understood that they needed to work hard to take steps to keep justice within the Batei Din, within the Jewish context, if that was their goal. They needed to make the Batei Din attractive and appealing. Sometimes, as I said, they needed to threaten people with bans of excommunication and whatnot. But they also knew that they had very few tools of enforcement. And so there were very few ways that they could really demand, they could make as many demands as they wanted, but there were very few ways that they could really force people to turn to the Batei Din. And I suspect that in this context, against this backdrop, Rabbi Meir and his colleagues may well have thought to themselves that by admitting some of these local legal instruments and principles and norms that, as you said, their Jewish constituents expected to be upheld, by admitting them into Batei Din, that may have been, to their minds, an additional way of keeping the Jewish litigants within the Halakhic fold, within the Halakhic system, right? They could use the local norms, they could use the local legal instruments that they were dependent on in the Batei Din, and so perhaps that might lower their motives, lower their instinct or their motivation to turn to other kinds of legal authorities. It might encourage
lower
them
the
to stay within the
incentive.
rabbinic system. I'm sorry?
To lower the incentive to leave
To
by
lower,
being
thank you very
more
much. Yes, to lower
inclusive.
the incentive, exactly. By enabling them to use those principles and those documents and other instruments in a Jewish court, it lowered their incentive for turning to other outside authorities, which was ultimately the goal of Rabbi Meir and his colleagues. And I just very quickly want to follow that up with a quick look at this, by the way, I'm sorry, this is just the map that we keep referring back to. This is a basic overview of the geography of the German Empire, which is where we're really focusing our attentions. This is at the beginning of, as you can see here, around 1200, at the beginning of the 13th century. By the end of the 13th century, there were many more Jewish settlements, Jewish communities that had been established, but this is the general geography. This was our general timeline. Again, last week we focused on Meir ben Baruch. We're going to see another responsum by this scholar today, as well as by an additional one of his students. But here's what I wanted to show you. This is a snippet of a responsum by Rabbi Meir ben Baruch. It's in the context, Rabbi Meir was asked to adjudicate a dispute between a mother and her son over an inheritance matter. And by the time the case was forwarded to Meir ben Baruch, an initial Beit Din, a local Jewish court, had already ruled in favor of the mother. The son had appealed their ruling. And in the context of the appeal, he seems to have turned in parallel to a local ducal court, meaning to the court of a duke, to a non-Jewish court, to try and extract some of the property that apparently he didn't feel the Beit Din was awarding him. And in responding to this case, by the time it got to him, Rabbi Meir ben Baruch, this is a small snippet of a much longer responsum, but I thought that this is an important statement to keep in mind. He wrote, regarding that which he, meaning the son, threatens, that he wishes to lodge a complaint against his mother before the duke, even if she waives her legal claim. Behold, says Meir, this son is attempting to grasp the rope at both ends in his desire for their law, dinehem, and our own dinenu. And we saw these phrases, this terminology, dinehem and dinenu, their law, our law. We saw that last week, and I want to again underscore that very keen awareness on the part of the halachic authorities as to this distinction. But Meir follows that up by saying there is a great difference between their law and our law. Again, in this specific legal context, he means it is appropriate to excommunicate him for these words and to separate him from the nation of Israel. And again, this is just one expression of really the opprobrium of the wrath, you could even say, that these scholars reserved for those who sought to adjudicate their cases, to pursue justice outside of the Jewish context. Okay, with that, I'm going to stop this. Yes, please.
So whereas the courts, the Jewish courts, try to use the secular law to buttress theirs when possible, some of the Jews try to play one off the other to help their own standing. So everybody was trying to jockey for superior position by using the secular court to their advantage. They
Yes, I
all
think
were
that's a very
familiar with it. They all were familiar with it and were trying to see which gave them the better, not which gave them the better, but to use it to their advantage within the framework of halacha, if that's possible, if I'm getting it right.
Yes. So I would say that, I think that what you just said in terms of, using the legal options that they had to their advantage, I think that very much characterizes many of the litigants who are portrayed in these responsa. And again, I think you also made another important point, which is that it becomes very clear that both the scholars and many of these litigants were legally astute. In other words, they knew what their options were. They knew what the likely outcome would be in these various systems, and they played them to their advantage when they could. And I think that maybe I should add here, in case it is not, I mean, it's sort of the premise, but just in case it has not been made clear enough, the medieval legal marketplace provided litigants in general, including Jews, with a plurality of options. Right? We spoke again. The Jews had the option of going to a local Jewish court, which in some cases, as we've discussed, was a learned rabbinic court. Sometimes was just a lay court, but they had the option of going to a Jewish court, which is of course what the Jewish leaders and the rabbinic scholars wanted them to do. But they also had the option technically to turn to a variety of different local courts. Right here in this particular case, the discussion is about the court of a duke, right? So a comital court, a ducal court. But there were, of course, there were municipal courts, there were market courts, there were guild courts, there was, again, within the local system, a whole slew, a whole array of different legal venues that people were able to turn to. And the Jews were aware of that, and the Jews took advantage of that when it suited them. And here I'm talking again about the litigants. I think the other thing that you said is also very true, which is that for the rabbinic scholars, their motivation was to keep these Jewish clients within the Halakhic fold. And yes, the argument that I'm making is that in their attempts to do so, one of their tactics was to try sometimes and admit local law into the Halakhic system, into the Batei Din where they could, if that would be an effective way of keeping people within the rabbinic courts. That is, yes, that is what I was suggesting. Okay. What I'd like to do now, I'm going to stop this particular screen share, although we're going to come back to that PowerPoint. But what I'd like to share with you now is the handout that you should have received by email, and if not, it's in the chat. And these are the texts that we're going to be looking at, focusing on for the remainder of our class. Let me just get that up for you. Sorry, one second. Here we go. Okay. Okay, so the two responsa that we're going to be focusing on today, as you can see, the first one comes from the collection, one of the many collections of responsa of Rabbi Meir of Rotenberg, with whom we're already familiar. And if you just sort of scroll down visually, you can see that this first responsa, source number 1, is in fact signed by Meir. And so that is a responsa that was authored by him. The second responsum that we're going to be taking a look at, you can see it's also from that same Prague edition, that same collection of responsa by Meir of Rotenberg. But if you scroll down to the end of that responsum at the bottom of page 2, you'll see that that responsum actually was not authored by Meir, but rather by one of his foremost students, Rabbi Asher ben Yechiel, otherwise known as the Rosh. He became a very significant scholar on his own of his own accord, but he was one of the handful of students of Meir who kind of took over, became the outstanding halachic authorities in Ashkenaz following Meir's incarceration that we've discussed in 1286, and certainly following Meir's death in 1293. Now, Asher ben Yechiel, subsequently in 1303, as the result of a whole series of political events that made Jewish life in the German Empire at the end of the 13th century quite volatile, Asher took his family and emigrated, left the German Empire. A number of Meir students, by the way, were killed in 1298 in a series of violent episodes known as the Rindfleisch massacres. Asher was spared that particular fate, but following those and following a lot of other or related upheavals, he took his family in 1303, left the German Empire, and emigrated with them to Spain. He became a rabbinic authority in Spain. He set himself up in Toledo, and for the second part of his life, from around, again, 1303, maybe 1305, by the time he reached Spain, through the end of his life in 1327, he became one of the foremost Spanish authorities. Anyone who has an appreciation of the distinctions, the differences between Ashkenaz and Sfarad, certainly in the medieval period, can appreciate why that was quite significant. Here we have an emigre who not only makes the transition, but actually becomes, really an authority in his new place. But it is important to remember that although he is often, as a result, thought of as a Spanish Rishon, in fact, Asher ben Yechiel was not only trained and raised in Germany, he actually spent the majority of his mature adult career in Ashkenaz, in Germany. And although much of the scholarly work that he left behind was from the Spanish period, which contemporary historians believe was in large part because much of his earlier scholarship probably got lost when he emigrated, we do possess a number of responsa that are clearly from his German period. And this one that we're going to be taking a look at today definitely is, right? This is not a Spanish responsa of Asher, but rather one of his Ashkenazi pieces from the Ashkenazi phase. Okay, with that introduction, let's take a look at the texts themselves, and let's see what the halachic issues we're going to be grappling with today are. So I'm back up to source number 1. And here, again, as we've discussed in earlier classes, some of these responsa contain the original query that was sent to Meir or whoever the halachic authority was, but some, like this one in front of us now, the original query was lost or was, simply excised by later copyists. Here in this particular case, the question was summarized seemingly by Meir himself, although it's hard to know exactly whether it was Meir or whether it was a later copyist. But we have a very brief summary of the question. We don't have the original question. Sometimes we don't even have the summary. Sometimes we just have to piece together the question on the basis of the answer. But here the summary is as follows. A question concerning Reuben, and again, I'll remind you, Reuben, Simeon, these are stock names. We can assume that these are not the original names of the litigants. A question concerning Reuben, for whom Simeon became a guarantor to a non-Jew. Right? Let's just think about this for a moment so that we have the relationship straight. Right? Reuben is our protagonist here. Reuben is the one who took out the loan. Right? So he is the debtor. And Simeon became his guarantor to a non-Jew. Right? So where does the non-Jew come in? What's the non-Jew's role here?
Reuben borrowed from him.
Okay, so seemingly Reuben, right, borrowed money from a non-Jew. Simeon, he set up Simeon as his guarantor for the loan that he took out, right? And he told the non-Jewish lender that Simeon would stand in for him, that Simeon would be his guarantor, again, if he didn't repay his debt on time, right? So let's read the continuation of that question or summary of the question, he stipulated with the non-Jew that if he did not give back the money by day X, that he would eat on him, right? And the specific terminology is sheyochal alav, according to the law of guarantors. And the question is, how should he repay the cost of the eating? Right now, it's again a little bit, there's a lot of he's and hims here. It's a little bit difficult to follow, but basically, he stipulated with the non-Jew. So Reuben, the debtor, stipulated with the non-Jewish lender that Simeon, the guarantor, would eat on him, right? And we're obviously going to have to explain that term, sheyochal alav, according to the law of guarantors. And now the question is, how should Reuben repay the cost of eating? Now, the first thing that's, again, so there we just have to keep the relationships sort of in order as we go through this question. But one of the things that we, of course, are going to have to explain is, okay, we understand we're talking about a loan. We understand we're talking about a guarantor who's supposed to back up that loan. But what is this strange business of sheyochal alav? Right? Now, if you take a brief glance at the Hebrew, you'll see that the law of guarantors, that term in the Hebrew is sheyochal alav b'din arev, right? Din arev is actually a Talmudic term. Certainly Talmudic law, Halakhah, recognizes the concept of a guarantor serving to back up a loan. But there's something here that doesn't sound very halachic, this concept of a guarantor eating. Again, we're going to have to clarify what that even means. That doesn't come from anything Talmudic. There is no Talmudic precedent for a guarantor somehow fulfilling his role by eating anything. And so that should already set off some kinds of alarm bells that something strange, something not entirely halachic is going on here. Now, I'd like to take a look at the response, although we have not yet clarified the question entirely. I'd like to take a look at the response and see if that helps in any way understand what's going on here. So Meir writes, there is no time to elaborate. I will respond briefly to you, my acquaintances. And by the way, this is in fact one of Meir's briefer responsa. We have seen some other pieces by Rabbi Meir now, so you will appreciate that here he's pretty concise and to the point. He doesn't belabor it, and perhaps, in fact, we do hear this from respondents from time to time, that they were asked to adjudicate certain cases, or they were asked to respond to certain halachic queries when they really didn't have time to spend a lot of time, with the question, or a lot of time writing up a whole argumentative response. Perhaps that was in fact the case here as well. So in brief, his answer is, right, and by the way, he says, I will respond briefly to you, my acquaintances. We don't, in this particular instance, we don't know who Meir addressed his response to. I think we can sort of assume, as we've discussed in the past, that he's writing to a local court, right, to local dayanim, to local judges who questioned what to do in this particular instance, how to rule in this particular instance, consulted with Meir about it. He certainly refers to them as colleagues, but he doesn't name them, and we have no way of really knowing. So here's his answer. Reuben should repay only moderate eating, as is the way of Jews who eat in a Jew's house to eat. That is moderate and limited eating. For it is the manner of the sons of Abraham, Isaac, and Jacob to have mercy on their fellows. And certainly this poor one, right, and presumably we're referring to the debtor in this case, who left the house of incarceration, who needs mercy, and not to eat on him with cruelty. Therefore, if Simeon ate excessively with cruelty, including delicacies that are not after the manner of other Jews who serve as guarantors for their fellows, and the host calculated accordingly, he must himself repay, that is, Simeon must himself repay everything that exceeds moderate eating. But if he did eat moderately and the host, however, calculated unjustly, nonetheless, Reuben should repay only the value of moderate eating, as is the way of all the land, and Simeon will go to court with the host if it seems to him that he is being unjust. And even if the host takes advantage of Simeon, Reuben should not lose thereby, for he can always say to Simeon, you are the one who caused this problem, for you are the one who made this condition with the lender. Okay, so again, there's a lot of things, a lot of questions, question marks that this raises, and a lot of things that we don't fully understand about this. And just I just wanted to share with you on a personal note that in some of my academic research, some colleagues and I came upon this and a series of other responsa that refer to this whole concept of eating on the debt, which again doesn't have a halachic precedent, is very baffling to anyone who is assuming that what we have here is a halachic authority answering a halachic question. What in the world is going on? And my colleagues and I were working together with a bunch of our German historian colleagues, whose field of expertise is not halachic scholarship at all, but rather medieval German law. And we showed them this particular piece. We gave them a little bit of background. We tried to explain to them what was going on here. And they said to us right away, oh yeah, we know what this is talking about. This is talking about a very basic medieval German legal instrument or legal concept, a form of guaranteeing loans in medieval Germany that was very common in medieval Germany, that was known by the term Einlager, which literally means to kind of quarter in, to like put yourself up at someone else's home, or to kind of put yourself up to again einquartieren, to quarter yourself in someone else's abode. And they explained to us that what was very common in medieval Germany at precisely the time that Mayer was writing here, is that, again, there were various, taking loans was very common, in part because they didn't really have an official banking system. And so individual money lenders, and again, we know that Jews were often associated with money lending, but they were by no means the only money lenders. And I think, by the way, it's very striking in this response that here the Jew is taking the loan from the Christian and not the other way around. This was just, again, individuals lent to one another all the time. That was one of the basic ways that the economy worked. But they obviously needed some means of securing the loans that they gave. Some of the loans were larger, some of the loans were smaller, but they all needed to be secured in some way. Small loans might have been secured with pawns. That was a common way of securing relatively small amounts of money. Sometimes lands were pawns if it was a bigger sum. But using guarantors was also a very common technique. Now, a guarantor, that we usually think of guarantors as pledging to step in and repay the loan in the event that the debtor defaults, right? That's how we usually think of guarantors. But in medieval Germany, one of the options, one of the ways that a guarantor could take responsibility for his fellow's loan, could serve as a guarantor for his fellow's loan, was not to assume financial responsibility for the original loan, but rather to pledge, and this is exactly what the piece seems to be talking about, to pledge that if the debtor defaulted, that is, if the debtor did not repay the loan by whatever date had been agreed upon, then the guarantor, again, rather than stepping in and fulfilling the pledge, the guarantor would, again, in the standard medieval German context, the idea is that the guarantor would in fact move into the home of the lender, or sometimes move into a reputable inn that had been agreed upon in advance by all parties, and begin to eat and to rack up costs that would ultimately be billed to the borrower. Let's think about that for a moment. How does that function as a form of guaranteeing the loan? Right, ultimately it adds to the debt, right? Because now the borrower has to pay back the original loan plus all of these accruing costs of accommodation and food and eating that the guarantor is racking up. And by the way, this was oftentimes, these guarantors were oftentimes knights or other kinds of people of that class who would move into these inns, not only by themselves, but also with their horses and with other animals, and they would have to be fed and taken care of. And so the costs would very, very quickly accrue. So again, how does that serve as a form of guaranteeing a loan?
That would encourage you to pay it back.
Yeah, it served as it's kind of a pressure system, right?
It's a
It would
deterrent.
encourage, exactly, it would encourage the borrower to really quickly get his act together, even if maybe he had to take out additional loans to get the cash, but to really quickly get his act together and repay the original loan before these costs, kind of blew out of control. And I think we can get a sense, even just from the responsum that we just read together, right, which kind of warns Jews who engage in this system, Jews who serve as this type of guarantor, to eat with mercy, right? We can already begin to get the sense, as a matter of fact, it's kind of explicit here, right, that these guarantors, this type of guarantor had the reputation of oftentimes, again, as Mayer wrote, eating with cruelty. In other words, racking up the living the good life. And this is perhaps why people agreed to be guarantors of this sort, really taking advantage of the situation and accruing excessive costs for the original debtor. And again, the function was to really quickly pressure the original debtor, the original borrower, to repay his loan. Now, what's really interesting is that, first of all, that Jews participated in this system, which, as I said, does not have a halachic precedent, and we're going to see that very explicitly afterwards. What's also particularly interesting about this specific responsum, I think, is that Mayer doesn't go into the background here. As we saw last week, Mayer is obviously very familiar, right? Mayer and his interlocutors, right? Again, he said this is a brief responsum that he wrote, but it's very clear that both Mayer and his questioners were intimately familiar with this whole system of guarantorship, despite the fact that it did not originate in Halakhah, that it was a local legal instrument, and therefore they didn't even bother to go into the details here. Mayer's point was to warn Jews who served as guarantors of this nature not to take advantage of the situation, to be merciful, to act with, Jewish values, to keep in mind that the person for whom they agree to secure the loan is not in a strong position here. And even though they have to start, again, eating or accruing these costs that are part of the deal, that they should do so in a moderate manner, as Mayer spelled out here. So it's kind of, I think what we see here is Mayer kind of embracing, again, this local legal concept, but bringing it into the halachic fold by sort of lending it a distinctively, at least in his mind, a distinctively Jewish character, right? Warning the Jews to act as Jews in this context. And I want to take us to stop here for just one very brief minute. I hope that this will not waste too much time. I want to go back to the PowerPoint for 1 second to show you something. I mentioned to you again that this was a local legal instrument, and I just wanted to show you, I think sometimes these visuals are helpful. We know about this form of guarantorship, again, which I said in the local context was known as Einlager, from all kinds of documentation. Again, we're talking about non-Jewish, local Christian documentation, including personal debt contracts, as you see here before court record books, rules and statutes from the medieval German Empire. The picture that you see here is an example of a personal debt contract. It happens to be that this particular debt contract, as you can see at the bottom of the screen, was written for a particular Count Ulrich of Montfort, who borrowed money in that case from a Jew in Lindau. And as part of, in the context of borrowing the money, he provided the Jewish lender with guarantors who were going to perform this form of guarantorship, who were going to start, again, moving in or eating and accruing these debts in the event that he defaulted, right? So this is again, as far as the Jewish, non-Jewish dimension is concerned, this is the opposite of our case in the responsum. Here, the borrower is a local count, non-Jewish count, obviously, and the lender is a Jew, whereas in our Halakhic context, we saw that it was actually the Jew who was the borrower and the Christian who was the lender. But this is the kind of, again, document that that we might be talking about. And by the way, I just want to very briefly point out, this is another responsum by Mayer concerning, again, this whole phenomenon where Mayer, I'm not going to go into this at great length right now, but here Mayer refers explicitly to that kind of document that we just saw. So again, to underscore what we saw last week, Mayer's extensive familiarity with these kinds of local non-Jewish legal documents and instruments. Here he writes, again, let's just read it very briefly, regarding Reuben, who owes Simeon a maneh, and made Levi and Judah guarantors that he would repay him the money by X date, right? So here we have a case where all of the actors are Jewish, right? And despite the fact that all of the actors are Jewish, meaning the borrower, the lender, the guarantors, everybody's Jewish. And again, Halakhah provides ways of guaranteeing loans, but instead, despite the fact that they're all Jewish, all subject to a halachic system, nonetheless, they use this local form of guarantorship. The guarantors pledged to Simeon that if Reuben did not repay him the money by the date he set, they would eat 2 meals every day on Reuben. In other words, they would eat 2 meals every day at Reuben, the borrower's expense, until he repaid Simeon, right? So in order to, again, put the pressure on him, raise his bills to get him to repay Simeon as quickly as possible. Reuben agreed to this, and he wrote a promissory note for the guarantors, and he gave a handshake, all committing to redeem them and to compensate them for all the sustained losses, right? Because the person who would initially put out the money would be the guarantors themselves, but he was promising to pay them back. And about this, he wrote a document, and in that document, the handshake is recorded. And then now Reuben has died before the date when the payment was due, and we can understand why there gets to be a conflict there. But the point that I want to make is that document that Mayer is referring to in this responsum is something like this document that we see here. This is, again, a Latin document written by a local count, but that's the kind of document that these Jews would have written as well. We're gonna go back to our responsum in just a moment, but before we do, I just wanted, again, sometimes I think the visuals are helpful. This responsum, this is what the manuscript of the responsum that we are looking at right now, this responsum by Meir Ben Baruch, the one on our handout on our PDF file, this is what it looks like in manuscript form. This particular manuscript, as you can see at the bottom of the screen, is from the Palatina Library in Parma, Italy. And the responsum that we're about to take a look at now, the second responsum that we're going to be looking at today, this is what it looks like in one of its original manuscript forms. Again, this manuscript here is from Mantua. It's a 15th century manuscript. The manuscript that we just saw over here is also a 15th century manuscript from Parma. So these are by no means the autograph manuscripts. In other words, they're not the original correspondence of Meir or of Asher or of anybody who was involved in the original case. These are later copies, although they're still medieval copies of the correspondence, again, underscoring the fact that these, again, very specific responses to very specific cases were understood by scholars to have long-term value, to be valuable as halachic precedent or valuable for the halachic argumentation contained within, and therefore they were preserved despite the fact that the case was over and done with, right? Okay, let's go back to that second responsum now, because the second responsum that we're about to see is going to, I think, help us understand yet further how halachic authorities dealt with this, again, this clearly non-halachic local legal instrument and how they related to it as Halakhic scholars. Again, as we said a little while ago, this second responsum was authored by Asher ben Yechiel, a student of Meir of Rothenburg. So we're still, again, this is while he was still in Ashkenaz. We know he left Ashkenaz in 1303. So this responsum must have been written sometime at the end of the 13th century prior to his departure from Ashkenaz. We don't exactly know who it was sent to, although here in this particular case, the Beit Din is named. It's our teacher, Rabbi Schneer, and his colleagues. We don't know much about them, but at least they are named here. Once again, we don't have the original query that was sent to Asher ben Yechiel, but we have Asher's response, and from the response, we can sort of put together, piece together what the question was. So let's take a look at it. Asher writes as follows: greetings to our teacher, Rabbi Schneer, and his colleagues. In my humble opinion, it seems that since Reuben did not eat in the home of Simeon as he pledged to do, he becomes the debtor and is obligated to repay. Okay, now let's just take a pause for one moment and understand who the characters involved are, right? Reuben, in this case, is the guarantor, right? Now, by the way, we can assume that the Reubens and the Simeons here are Jewish, right? I think that's pretty clear, right? So Reuben, a Jew, is the guarantor, but he had pledged, in this case, to eat at Simeon's home, which means that Simeon is who? What role did Simeon play in this case? Simeon was, in fact, the lender.
The lender.
Right? Because the guarantors eat at the home of the lender, or again, either at the home of the lender or an agreed upon inn, but here it seems to be in his home, right? So Simeon was the lender, Reuben is the guarantor, and we're going to hear a little bit later on that in this case, the borrower was a Christian, a non-Jew. Right, so interesting, right, just to take note of the fact historically that Jews seem to have served as guarantors for fellow Jews, but also for Christians, right? We see Jews in all three of the relevant roles here. Okay, so here the issue is that Reuben, the guarantor, had promised that if the Christian borrower defaulted on his loan, he would start eating in Simeon's house right away, right? But he didn't do what he had agreed to do as a guarantor. What happens then? And right up front, Asher says, well, he becomes the debtor, right? He was supposed to start eating as a means of putting pressure on the debtor, on the borrower, who again, in this case was a Christian, but he didn't do that. So by not doing that, by agreement, what happens is that then he himself assumes responsibility for the loan. He becomes the debtor and he is obligated to repay the loan. And he may no longer eat, right? He can't subsequently say, okay, I'm now gonna do what I was supposed to do and I'm gonna start eating. For the current practice among guarantors to eat on the dead, again, this phrase le'echol halachov is not something we find explicitly in the Talmud. And here I really want to underline, right? This is one of the points I want to underscore here, right? This is not something we find explicitly in the Talmud. Rather, they act, meaning all the parties here, all the parties to this legal setup here, are acting in accordance with the manners of the nations of the world, b'nimusei umot haolam, and like the norm of the land, kiminhag hamedina, which is closely related to that dina de malchut dina that we discussed earlier. And therefore, one should follow the local norm. And so we find in the Talmud that if the practice among locals is to legally acquire things in the manner of acquisitions that the sages did not institute, the norm is affected, as it is taught in chapter Ribit, which is from Baba Metzia. Rav Papi said in the name of Rava, in the case of labeling an item with a marker, affects acquisition, and he concludes that in a place where the custom is that the marker actually affects the acquisition, it affects acquisition, right? We're not even going to go into the details, that's the point. And similarly, regarding a manner of acquisitions that the sages instituted, if the locals are not accustomed to acquire things thereby, the custom overrides the law. Haminhag mevatel halakhah, such as a place where they do not acquire with money, right? The emphasis here is that he's saying, halachically speaking, minhag mevatel halakhah, right, is the local norm that really kicks in. And so too in this matter, it is the established law in all the places that if a guarantor missed a single meal, he has not eaten in accordance with the law of guarantors, hence he becomes the debtor, right, meaning the responsible party, and is obligated to repay the original debt. For if it were not so, he would forever postpone eating. And when they forced him to court, then he would say, okay, I'm ready now, I want to eat. And his claim that he needed to eat for a non-Jew, meaning a different debtor, is no claim. For a person where the guarantor in 6 places, should 5 lose their money while 1 eats for the 6th. Rather, the law is that he should appoint another person to eat him instead, right? So here we hear about someone who apparently was like a professional guarantor. He had various clients, and he claimed that he didn't start eating for one because he was eating for another. That's no excuse, says Asher, right? He has to appoint a proxy. And furthermore, why did he not eat for the Jew and postpone the non-Jew? Indeed, which one of them would you leave out? Hence, it is no claim. Therefore, Reuben should repay half the money, that for which he was responsible. And with regard to the second half, since Simeon acknowledged that he had a second guarantor, and the admission of litigant is like the testimony of 1,000 witnesses, he thereby exempted Reuben for responsibility for half the money. And the responsum goes on. We're not even going to read the rest of it because it's not relevant to the main point here. The main point that I really wanted to make clear is that Asher states very, very clearly here that this is not Talmudic Halakhah, right? Talmudic Halakhah actually can't provide an answer for the dispute that has been referred to him, right? Talmudic Halakhah is not going to guide anyone as to whether, what should they do now that Reuben the guarantor hasn't started eating when he was supposed to be eating, because this whole business, this whole method of guaranteeing a loan is not found in the Talmud, as Asher says very explicitly. But nonetheless, Asher is engaging with this question as a halachic scholar, and he has guidance to offer as a halachic scholar for what the parties should do in this particular case, right? And he thinks, at least, that he's being very clear about it, because he concludes his responsum. It seems to me that I have explained all that is necessary, that there's no further doubt concerning the matter, right? Peace, shalom, Asher ben Yechiel, may his memory be a blessing, right? And the reason I think that he is so confident about it is because of these concepts that he cited at the beginning of his responsum. Right, this idea of that when one acts in accordance with minhag hamedina, then by halachic law, by halachic rule, the case should be adjudicated in accordance with the norms of the land, with the local norms. So I think, once again, keeping in mind what I said at the beginning of the class, once again, what we see here is a halachic scholar who is, again, not only very familiar with the local norms, but very willing to engage with, to adjudicate according to admit into his courtroom these local norms, right? There's no finger wagging, at these litigants for having chosen to guarantee their loans, even again in the cases that were all internal, right, all between Jews. There's no finger wagging saying, why did you choose to guarantee your loans in this non-halachic manner, right? That doesn't enter into the discussion here at all. It's kind of accepted by Meir and by Asher that this is a way that Jews at the end of the 13th century choose to function, choose to conduct their finances, despite the fact that it very clearly, by everyone's admission, originated outside of the halachic system. But nonetheless, these halachic scholars engage with the questions. They are willing to offer guidance as to how the Jews should behave in these circumstances, but the guidance is all predicated on what local norms dictate, what local norms are in these particular instances. And here, once again, I just want to suggest that quite likely, as I suggested at the beginning of class with regards to the material from last week, part of the motivation, again, there are all kinds of halachic, as we saw, halachic frameworks that allow for the introduction of these kinds of economic mechanisms from outside the system. But quite likely one of the motivations for Meir, for Asher, and for other respondents who contended with this was that it was a means they recognized that Jews were functioning in this manner, and dealing and contending with these cases was a means of keeping the disputes as much as possible within the confines of the Jewish court system, the Jewish justice system. And as we saw in the case of Meir, perhaps also influencing the behavior of Jews who chose to use these instruments to remind them that even when they were adopting these local legal norms, they should conduct themselves as Jews within a Jewish moral framework, even if not within a strictly Jewish legal framework. Okay, that's what I have to say about this. But if anyone has questions to ask about this, I'd be happy to entertain them for another couple minutes, and with that, we'll conclude for today.
I have a question.
Please.
Do we see from this that in cases where the lender was non-Jewish and the guarantor was Jewish, that they ate in a non-Jewish house? And what did they do with all the prohibitions about eating with non-Jews, kashrut, and all those things which were around in the medieval period?
Yeah, so that's an excellent question that I do not have an excellent answer for. Again, as we saw, there's all kinds of constellations here of relationships between the guarantor, right? So certainly it seems like there were Jews who functioned as guarantors for Christian, again, lenders, which means that ostensibly they would be eating in the Christian homes or in these inns, oftentimes in the context, oftentimes, although it doesn't come up here explicitly, in the archival documentation, it becomes very clear that oftentimes the guarantors would go to these recognized inns. So it's possible, we do know that there were there were Jewish inns already, Jewish kinds of, taverns, inns at this point in time. It's conceivable that when Jews functioned as guarantors, they might have stipulated from the outset that if they were to have to start eating, that they would eat at this, inn, this local Jewish inn, let's say, where they wouldn't have a kashrut issue. But what we know for certain is that, this is the flip side of your question, definitely Christians, sometimes Christian guarantors ate in Jewish homes, which again might not raise the kashrut issue, but certainly raise these issues of the eating together that you mentioned, which is again part of all of ostensibly part of the backdrop to all of these rules concerning bishul akum, etc. I don't have a very good answer to what I think is your underlying question. It raises a lot of questions for us as historians about the norms and behaviors of these communities that are definitely worthy of further investigation. Yeah.
Okay, thank you so much, Rachel, and thank you everyone who joined us, not only here in Zoom, but also on live on Facebook. I don't see any questions on Facebook, so I think we can close for today. Just a couple announcements that this Thursday at 12:30 p.m., Sofia Stepansky will be teaching as part of the discussions on the Parashah class. Also, this weekend, the US is switching over to summertime. So if you're joining from Israel next week, just make sure that you are keeping mind of the time. So for example, this class, well, I don't know the exact timing, but just to kind of remind you to double check. But anyways, we will see each other next week. Thank you so much.
Thank you.
Bye-bye.